various authorities that have been cited, and more particularly, my Lord, the Munya case, which
my Lord, I want to apologize if I appear to take judicial discretion from you. It was intended to keep my promise to you that we will be quick.
We now get to know that every side has a prefect. This side, the prefect is Professor Chini.
my Lord, just want to also add my voice to the submissions that have been made by the respondents. We should go on record that my name is Shara. I'm also the Solicitor General for the Attorney General, together with Professor Muite and Charles Mutinda and the rest of the team. Yes, my Lord, to say one or two things so that we wrap up submissions from our end. My Lord, it is not in contestation that under Article 145(7) of the Constitution, a final decision of impeachment was made. It is not in doubt, and that has not been controverted by either side.
Well, we have. That is what we have challenged.
A final order to this, my Lord, was made. Secondly, my Lord, it is also not in contestation that a vacancy has arisen or arose in the office of the Deputy President. It's also, my Lord, not in contestation or in doubt that Article 149 of the Constitution was invoked in terms of the President nominating Professor Abraham Kithure Kindiki as a nominee to that position, and that Parliament voted on the same. And I would agree with my learned colleague who has just left the floor, Mahat, that the framers of this Constitution never intended that the IEBC plays a role when it comes to the issue of impeachment. And my Lord, if they so intended, nothing could have stopped them from expressly stating that position. And therefore, my Lord, I am submitting that the interim orders that were granted and are in place cannot cure that position. And therefore, my Lord, relying on the various authorities that have been cited, and more particularly, my Lord, the Munya case, which is a classic case in terms of what will be required in the grant of conservatory orders. It is my humble submission, my Lord, that that has not been made. And I would also submit, my Lord, that when you look at the greater public interest, my Lord, we want to persuade you with the very many other arguments that have been given by my learned colleagues, that you will find favor that the discharge, the vacating, or the varying the orders that have been in place would find greater good than holding those orders in place. And therefore, my Lord, to conclude, I would urge my lady and my lords to find that we cannot continue holding the country at ransom. We need to make a decision that some of the roles and the responsibilities that are played by the President, which are currently at a standstill, would be extremely critical that the moment these orders are vacated, the rest of the processes should be allowed to be completed. I therefore humbly submit that you discharge the orders that are in place and allow the entire process to be completed. I submit, my Lord.
Thank you.
My lords, I want to confirm on behalf of the respondents that we rest there, but with your kind indulgence, if there is to be a reply, I think again we need to remind ourselves that it ought to be on points of law. If the case is rehashed afresh, we would still be here tomorrow and it would contrary to procedure.
My Lord, I also request a direction on whether persons who are not parties to the application, because there are only 2 applicants, have a right of reply, because my understanding is that the only persons with the right of reply are the parties who filed the application, not the entire coterie of this side.
Thank you, Doctor.
Okay, 2 things.
Why are we being preempted?
2 things on way forward. I think we still have to be interested parties, or do we have them?
No, no.
We did that.
We did that.
We finished with yes, now, the right to rejoin that is only limited to the applicants and not any other person supporting the application. So it will go only to the applicants. And in this case, we have 2, and they will have how much do you think?
You have given us 30 minutes. I am addressing the court, please.
Yes.
Reply to the court. You have given us 30 minutes.
That's okay.
Do we do 15 or 20?
Look, my Lord, there is a lot as we can pass. In fact, they have given us the impression that they will read later than now. They have obviously done 4 hours and something. We want the worst things that we can do within 5 minutes. Or less, depending on how much he's able to cover. The only issue, my Lord, that is the mischief is that since this is a court of record, we do not want to be accused there is anything that needed a response that was not responded to. Otherwise, I'm very tired. We don't want to be here forever. So we just are here to do the business and we go.
Okay, this is the way forward. We will give the respondents the time they need. 30 minutes. Not the respondent, but the applicant. 30, let's go.
My Lord, may I please report on the same issue, because I've been standing and I did catch your eye. Still on the issue of the right of reply. My lords, you might remember that I am, first of all, I am one of the represented petitioners of petition 11. And for the my lord, you might remember that for the last 2 weeks when this matter has been being handled, I have been insisting that we made an application for conservatory orders prior to even the applications we are discussing now, and it was in the best interest of all of us that when discussing the conservatory applications, we be treated as respondents. My lord, unfortunately, when the court gave directions, it consolidated all the petitions, but did not give directions on how our applications would be had.
Now, Mr. Bosso, just a minute. We will restrict ourselves to the applications at hand.